I just wanted to do a quick little addendum or additional statement on the courts section. As I've been talking to students and answering questions and going over things to prepare for the tests, there are a few things I thought that needed to be clarified. So I'm going to go ahead and do that real quick. So here we go. First, when we talked about plea bargains and some of the controversies over plea bargains, some students kind of took it that plea bargaining was always a bad thing and not good, but there are some actual good reasons for plea bargains. A couple of them, for example, one would be leniency for extenuating circumstances. So, for example, imagine there's a high school senior, he is 18 years old, and his grandmother dies, and he's real upset, and that day, as he's upset, walking through the halls, something happens, and he ends up getting in a fight. But he's 18, he gets arrested and charged with assault and battery. Technically, he committed a crime, potentially there, but a prosecutor might be able to look at that case and say, you've never been in trouble before, you don't have a record, we understand, the situation, your grandmother just died, you're really upset. We don't want to completely not charge you because that's not fair to the victim, but at the same time, we don't want this to be something that ruins your life because, now you've been charged and convicted of a violent crime. It affects your job possibilities and things like that. So in a case like that, they might plea bargain to a lesser charge so that you're not having your life ruined. So for example, they could plea bargain to a lesser charge or plea bargain to something like having adjudication withheld, which means that you are found guilty but not really found guilty. They're withholding the judgment of guilt so you don't have a criminal record. So there are some ways that they can use plea bargaining for showing leniency when the situation warrants that. Another one is that plea bargaining saves time and money for the system. When 90-something% of cases are plea bargained, that means they're not going to trial. If a bunch of cases start going to trial, then that's going to take more money for trials, it's going to take more time, more people are going to get called for jury duty, it just becomes a big burden to society. So avoiding the whole trial system is a net good for society in that sense. So just to clarify, there are controversies with plea bargains, but there are some reasons that plea bargains exist. Also, I want to talk about the Dred Scott, Plessy v. Ferguson, and Brown v. Board of Education decisions. There's several cases that you need to know for the courts unit, and then more that you'll learn about later when we get to SCOTUS, which is Supreme Court of the United States. But right now, these three cases go together, and it's really important that you understand how they're connected, and it's important to understand that they go in a specific order. Like, I generally don't worry about the dates for court cases, but some of the court cases, it's really important to know generally when they happened because of the situational circumstances, what was going on in society at those times. So we're going to talk about each one of these, but before we talk about these court cases, we need to understand something called the Reconstruction Amendments. These are the three constitutional amendments that were created during the time of Reconstruction after the Civil War. So this includes the 13th, 14th, and 15th Amendments. The 13th Amendment freed the slaves. Now you might know the Emancipation Proclamation freed slaves, but that only freed slaves in slave territories in the Confederacy. It did not free all slaves. So the 13th Amendment was a constitutional amendment that completely freed slaves anywhere in the country and ended slavery in the United States. The 14th Amendment gave former slaves citizenship and all citizens equal protection. So this is something sometimes called the Equal Protection Clause, that all citizens have equal protection. The 15th Amendment gave voting rights to all citizens, including former slaves. Now, it's important to think logically about this order. So if you're ever asked, which one's 13th, which one's 14th, and which one's 15th, they go in an order that is pretty logical. You cannot give voting rights to former slaves before you free the slaves because it doesn't make sense that you'd have slaves able to vote. Okay? In order to be a voter in the United States, you have to be a citizen. So citizenship has to come from that. So the order is you free the slaves, then you give them citizenship, and then you give them voting rights. It's in that order, because obviously if you change that order, it messes things up. So that's it, 13th, 14th, 15th Amendments. Now, when we get to Dred Scott, Plessy, and Brown v. Board of Education, First, we're going to look at the Dred Scott case. Dred Scott, the little background, he was a slave who was in a slave state, but then his owner took him to a free state and then eventually returned to a slave state. And Dred Scott claimed that having gone to a free state made him free, so that when he was brought back to a slave state, he should have remained free. And he sued. The court actually didn't rule on that issue at all. Instead, the court said that because he was black, he wasn't a citizen, and therefore he had no standing to sue. Standing is a legal term that means you have legitimate grounds or cause to go to court. So if I see a car crash, I can't sue because I wasn't in the car crash. I'm not a victim of the situation. So standing means you have to have some cause to be in that lawsuit. In this case, they said he didn't have standing because he wasn't a citizen, therefore the courts didn't have to do anything with him. That wouldn't fly today for a variety of reasons, but back then, that's what happened. So they didn't actually rule on the issue of freedom or slavery. They just said he couldn't sue at all. And again, this is before the Civil War, and that's important because he was not a citizen. He was arguing for his freedom, but he was not a citizen, and therefore the court said that he had no right to sue anyway, so they just booted the issue. And that's the Dred Scott case. Then, Plessy v. Ferguson. This comes after the Civil War and those Reconstruction amendments. Plessy was arrested for sitting in the whites-only part of a segregated train in New Orleans. And so that brought up the legal question: is segregation a violation of the 14th Amendment's Equal Protection Clause? So Plessy was actually part of an organization in New Orleans that was trying to fight for civil rights, and they orchestrated his arrest. They wanted him to be arrested because they wanted to have standing. They couldn't challenge a segregation law if nobody was being hurt by the segregation law. So instead, they set up a situation. They intentionally had him sit in a car he wasn't legally allowed to be in and get him arrested. So then he was a victim of the law, and then they could sue because they have standing. So they brought up the question. They claimed that segregation was a violation of equal protection. They said that equal protection says that all people must be treated equally, and blacks aren't treated equally under segregation. The Supreme Court, though, actually said segregation was constitutional under the separate but equal doctrine. That's what they created. They said, yes, segregation separates people, but as long as they're treated equally in their separation, then it's fine. And this argument was that blacks weren't treated worse in segregation. They actually argued that segregation treats everybody equally because whites are segregated too. Whites have to be in the white car, and blacks have to be in the black car. Now, obviously, I put a little asterisk there because we know today this is not a sound reasoning in any way, shape, or form, but that was their argument at the time. So that then leads to 1954, Brown v. Board of Education. Brown was actually 5 separate cases that were combined. So the NAACP, which is the National Association for the Advancement of Colored People, a civil rights activist organization, had been trying to fight segregation for many years around the country. And at this point, they had 5 different cases going in different states to argue for integration of public schools for K through 12. And 5 of them were combined in the Supreme Court, Brown v. Board of Education. And the NAACP in this case argued that segregation was socially and psychologically harmful. So in previous cases, they had actually fought under the separate but equal idea that blacks-only schools were not equal in quality, they weren't equal in funding and things like that. Well, now they were arguing that even if you could create a situation where they had equal funding and stuff like that, the simple act of segregating is harmful. And this is when the Supreme Court ruled that separate but equal is overturned. They overturned the Plessy decision, so Plessy was thrown out, and they argued that they decided segregation is unconstitutional, and they ordered segregation to be ended with all deliberate speed. That's an important quote in American history and American government because they didn't actually give a timeline for when segregation had to end. They just said with all deliberate speed, and some states were much faster than other states at ending segregation. And some of the southern states, segregation, even though this was 1954, segregation continued well into the 1970s. So that was one problem with Brown v. Board of Education. But anyway, that is a quick review of some of the positives of plea bargaining and just some background information on Dred Scott, Plessy, and Brown, because these three cases go together and it's important to understand how they go together. So if there's nothing else, make sure you smash that like button.